had an opportunity to review the probation violation report?
We have, Your Honor.
And hold on. For some reason I went in and out of Zoom. Mr. White Eagle, have you had an opportunity now to read and review the probation violation report with Ms. Underwood?
Yes, I have now.
Okay, are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
So far, yes.
Excellent. Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, it's my understanding from Mr. White Eagle, Your Honor, that Mr. White Eagle wishes to withdraw his plea to the violation and have a hearing on this matter, Your Honor. Mr. White Eagle contends that there was someone home at his house and he was asleep upstairs, and that's where all this comes from.
Miss Adams, can you call Miss Hennigan and tell them that Jackson County Jail has zoomed in?
Okay.
Good morning from at the Jackson County Jail.
Good morning, how are you?
I'm good, thank you. All right, and so the basis of his request, okay, the basis of his request to withdraw the plea is what?
The basis is that I believe, Your Honor, he felt once he looked at the probation department's description of offense, the offense, that it was not correct, that there were people there, that he was there upstairs, but when it says no one was home, that is incorrect.
What about the part
Is that the case,
report?
Mr. White Eagle?
Yeah, but what about the fact that he failed to report any time thereafter and absconded?
No, I
So,
don't.
Mr. White Eagle, hold on a second. You know, Ms. Underwood, I'd be more than happy to withdraw the plea and set it for a hearing next week. Ms. Adams, what day can I do a mock trial next week, please?
All right, right here.
20th
The 20th at what time?
at 8:15.
All right, January 20th at 8:15, Ms. Underwood.
Thank you, Your Honor.
All right, Mr. White Eagle will be back for a bench trial on January 20th at 8:15. Ms. Teskey. Ms. Teskey,
Yes, Your Honor.
consider yourself subpoenaed.
I will.
No, it's
All right,
fine.
thank you. All right, thank you. We'll see you back on that day, Mr. White Eagle.
Thank you.
Thank you. All right, Ms. Adams, if you can let the Lenawee County Jail know that I would like Mr. Renner. All right, in the matter of the people of the state of Michigan versus Brandy Michelle Bevere, file number 22-20772FH, Brenda Underwood appearing on behalf of Ms. Bevere. I do not see anybody standing up to be Ms. Bevere in the courtroom, Ms. Underwood. It's my understanding she has also failed to appear for a district court hearing as well. Is that correct?
That's correct, Your Honor.
All right, well, we are here on a controlled substance charge. She has failed to appear for sentencing. I'm going to issue a bench warrant for her arrest for failure to appear. And I will set bond in the amount of $150,000 cash.
Thank you, Your Honor.
Thank you,
And
Your
Ms.
Honor.
Underwood, yep, and Ms. Underwood, I believe that will conclude the matters you had before the court.
It is, Your Honor. Thank you. Have a good day.
For you as well. Thank you. All right, Ms. Hennigan. Are you here on Tate at all? All right, good morning, Mr. Tate.
Good morning.
All right, Ms. Hennigan, now you do have to drive faster. So this is in the matter of the people of the state of Michigan versus Harold Glenn Tate Jr. File numbers 22-20934 FH and 22-21132 FH.
Thank you, Deborah. I appreciate it. Thank you. I'll bring it back.
Mr. Coast, I'm gonna mute you real quick, Mr.
Oh, I'm sorry,
Coast.
Judge.
That's okay. All right, this is the date time set for sentencing in this matter. I have a pre-sentence report and I have an updated pre-sentence report that was prepared by Mr. Jones. The updated one is dated at the bottom, November 1 of 22. December 12 of 22. Which one, Mr. Jones?
It would have been the last one that he was charged with, Judge. So it would be on the,
Well, it looks like there's one for each file, right? You did a separate PSI for each file?
yeah, because they didn't combine them. So I believe the update's done on 132 FH by looking at the files.
I'm looking at 22 one. I have one for December 12 of 22, which is on file number 22-21132 FH. And then the one that has updated written on it, the top says 11223, and that's on the 22-20934 FH file. Do you have those, Ms. Hennigan?
I do not have the last one, Your Honor, the updated one.
The updated was just a couple corrections, Ms. Hennigan, I think that you came in and wanted me to do. So I just updated a couple pages and sent it to the court. It's not a full update. The full update, Judge, is on the 132 file. That's the new conviction report. Because when he was up for his sentencing on the first file, new charges were there and he pled guilty to another set of charges.
Yes.
Okay.
No,
Ms. Hennigan, it is 3 pages. The update, I'm going to have Ms. Adams come get it and email it to you.
Okay.
Okay. All right, so while she's doing that, Mr. Murphy, are you ready on Mr. Espinoza?
Yes, Your Honor.
All right, Mr. Tate, just bear with us for a moment. All right, this is in the matter of the people of the state of Michigan versus Jose Espinoza, file number 22-21014 FH, and Matthew Murphy appearing on behalf of Mr. Espinoza. Mr. Espinoza is present in the courtroom. Mr. Malaro, do you need to speak with Mr. Renner?
Just briefly, Judge.
So, Mr. Renner, I'm going to assign you and Mr. Malaro to breakout room. Go ahead and click on join that breakout room. All right, there is a letter in my file from Darren Post from Pretrial Services dated January 9th of 2022. States Judge Angelo, Mr. Espinoza continues to do 2 times a day PBTs. He has been testing since June and doesn't miss a test. He's doing well, sustaining from alcohol. So we have received that letter, Mr. Murphy.
Yes, Your Honor, I received that. Thank you.
All right, so Mr. Murphy, this is the date and time set for sentencing in this matter. Have you had an opportunity, Mr. Espinoza, to read and review the pre-sentence report?
Yes, I have, Your Honor.
All right, have you had an opportunity to discuss the pre-sentence report with your attorney?
Yes, I have, Your Honor.
Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
I am, Your Honor.
Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Before does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Probation Department has computed minimum sentencing guidelines to be 7 to 23 months. Do you agree with that computational guidelines?
After my review, I do agree with that, Your Honor.
Right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Espinoza?
Yes, Your Honor. Obviously, we've read and reviewed the pre-sentence investigation report. The recommendation we believe is appropriate in this matter. Obviously, we understand that the guidelines here, 7 to 23 months, I believe, this would be going below the guidelines. I believe that's justified in this situation. Obviously, there was a killer agreement to that. The prosecutors understood the situation. Mr. Espinoza, if you look at his criminal history, there was a long gap there. Obviously, there was some stuff in the past. This is the same reoccurring thing. Obviously, it flushed itself out because individuals with these issues with
Can you slow down a little bit?
individuals with alcoholism, it's a lifelong issue. And he understands he has to, approach it as such, that 10 years, 20 years, he's still gonna have to deal with that. Obviously, he understands that. So that's the court, again, for a sentence of probation to defer any incarceration. Obviously, Mr. Espinoza hasn't doing well on bond conditions. He has been testing regularly. He hasn't had any violations of that. I understand the recommendation for a scram unit in lieu of incarceration. Mr. Espinoza has expressed some concerns about the ability to pay for a scram unit. So I'd ask if possibly to do something in lieu of the scram unit. I don't know what we could do. I mean, obviously, the suggestion here was that be done in lieu of incarceration. I'd ask the court to just consider suspending the jail time pending any violation of his probation, because obviously he'll continue to test as he is doing right now. He hasn't displayed any reasons to not, he wouldn't appear anything that for a test. So I don't believe a scram unit is necessary in order to test him. I'd ask the court to consider that. Again, Mr. Espinoza has expressed a concern about being able to afford that moving forward on probation. That's again, Mr. Espinoza does understand. He does apologize for his behavior in this incident. He understands what he has to do to move forward to, not be in front of the court again. So I'd ask the court to consider again, not incarcerate him at this time, just give him probation moving forward. Thank you.
Thank you, Mr. Espinoza. Anything you'd like to say on behalf?
Oh, Your Honor, I, beside myself of being here, I don't know why, I don't know what the Lord has for me to save me, or because last time you saved me, I had 8 bid. This time, I'm beside myself. I don't know why I make these bad decisions.
Mr. Espinoza, you work for Edward White Contractors, and you typically are laid off during the winter, correct?
Correct.
And then you go back in the spring,
Right.
so you get unemployment during the winter?
Correct.
Okay. All right, and anything else?
And I work all over the state. That's why doing the breathalyzers on the road, that was a lot helpful, because not to have to come back to town, because I work up in the Detroit area, wherever, building roads.
That's fine. Okay, so would you say that you probably won't be going back to work until April?
April, May, probably end of April, May, all cross laws.
Okay. All right, anything else, Mr. Murphy?
Nothing further, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. As I stated, I did receive a letter from Mr. Coast regarding your drug testing and how well you've been doing. It's not common that we have people doing that well, so the court will take judicial notice of that. There also was a plea agreement in this file, and the court will comply with that. I am going to add some terms, Ms. Holly, though, to the probation terms. So it's sentence of the court that you would be placed on probation for a period of 3 years. During the term of probation, you will obey and comply with all the articles in your terms of probation. You will pay $750 in court costs, $450 in attorney fees. There is a $500 fine required by statute. There is a $210 OUIL, OUID reimbursement. 100 of that goes to the prosecutor. 110 goes to the Adrian City Police Department. $60 DNA fee, $68 in state costs, and a crime victim assessment fee in the amount of $130. There is a supervision fee in the amount of $30 per month for each month of regular supervision, and $60 per month for each month of electronic monitoring supervision. you don't leave the state for you stay in Michigan, right? I'm also going to, have you had an alcohol assessment done?
No, I just been to the probation. I haven't gone over. to
Okay.
the county.
So I'm gonna order that you are required to have an alcohol abuse assessment done. I'm also going to order that you attend 90 and 90 AA meetings. Since you're laid off, you have time to do that. I'm also going to order that you perform 60 hours community service. So that's, or I'm sorry, 60 days. So that's 8-hour days, 60 days while you're laid off. I expect you to crank that out this winter. Okay. I'm going to sentence you to 30 days in Lenawee County Jail as required by statute. Give you credit for the 48 hours you consecutively served and suspend the balance. Obviously, if you violate, you will serve the balance of 30 days, whatever else I require. There is vehicle immobilization. Your car is owned. So the car was registered to Concepcion Maria Rivera.
Correct, and I only used it for work, so I gave it back to her. I had got it out of my house, so I didn't.
So you have no vehicle?
drive it.
Okay. All right, and you live here in town,
Yes,
so you can walk if you need to, right? Okay, get rides.
right down, right
All
there.
right. Your driver's license is revoked for 5 years. You may hire an attorney at some point and try to get it restricted or something of that nature, but obviously that's not in the near future. And doing the 90 and 90 and continuing to attend AA and treatment is very important. When you have the assessment, you must comply with all recommendations. If they order counseling for a period of time, you will comply with that. Not to obviously use, possess alcohol, have it in your home. If you have a family gathering, there's no drinking in your home. Not to use any illegal controlled substance. Prescription drugs as prescribed only. You understand they have a right to search and seizure, and you must comply with whatever personal protection order there's in place. There must be one down the hall. I don't know anything about it, but make sure you comply with that. And let's see. Okay. So he'll be on colors for sure. Is that correct, Miss?
We don't usually do colors, but I can do whatever you want me to do.
Right. So I'm gonna put you on colors. I'm not gonna do the tether right now, only because you've been on bond conditions for a long time and done well.
I will do.
If there is one hint that you've been consuming alcohol, you'll be put on a scram unit. You understand? Okay. All right. Anything else, Ms. Holly?
No, I think so.
All right. Now,
Judge.
yes.
I'm sorry, did you immobilize the vehicle or no?
No, he doesn't have a vehicle.
Okay.
All right. So you do have the right to appeal this sentence. My bailiff's going to hand down to you your notice of right to appellate review. I'm going to have you sign the top copy for our records. The other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days for the other copies.
Yes.
So jail was deferred.
Yeah, it was part of the plea bargain that
Yeah,
people offered.
I just wanted to make sure you said it again.
Mr. Espinoza, I appreciate you brought your overnight bag. It's like over there, so.
So major.
So I wish you the best of luck and, you've kind of shown that you were serious about your sobriety, so I wish you the best of luck and hopefully I won't see you.
I'll make it.
All
Thank
right,
you, Your Honor.
Thank you, Your
the
Honor.
record should reflect I received back the notice of right to appellate review. Thank you. All right, Ms. Hennigan, have you received the paperwork from Mr. Tate?
Yeah, I didn't get the paperwork, but it was.
I can't hear you, Ms. Hennigan. Ms. Hennigan? Ms. Underwood, you still have somebody?
Well, I got, an email on Mr. Spresser, Your Honor.
I don't know who Mr. Espresso is. Becky, are you sending emails about Mr. Espresso?
Yeah, that's a pickup, Judge.
Oh, well, I don't know when I'm gonna get to that, so, is that yours, Michael?
No, I'm on Mr. Tate. Also, is Tamaris on that sentence? Does he have 2 sentences this morning?
Yeah.
Okay.
So, Ms. Hennigan, I know you have to be here. Do you have to be at the courthouse by 9?
No, Your Honor, it's a Zoom, but I was supposed to.
Okay, I can hear you now. Before you're really garbled. Okay, so let's move on to Mr. Tate then. All right, so Mr. Dagger Margosian, you represent Mr. Tate on file number 22-21132. Yes?
That's the controlled substance with the enhancement conviction?
Yeah.
Okay.
All right, so we're, Ms. Hennigan, do you need a moment to speak with Mr. Tate regarding the update to the pre-sentence report?
I do not, Your Honor, and I believe it probably was not sent to me because Mr. Dagger Margosian represents him on that second charge.
Okay.
But the update,
meet
I
Mr.
just
Tate?
added the additional charge.
Can I suggest that Tamaris and I and Mr. Tate
Yes.
all be in?
So do you want to go back to my jury room and zoom in? All right, so Miss Hennigan and Mr. Tate, Mr. Dagger Margosian would like a breakout room with the 3 of you to go over the pre-sentence report because Mr. Tate, you're in Jackson. So what I'm going to do is create a breakout room. And I am going to assign, as soon as Mr. Dagger Margosian gets here, the 3 of you to a breakout room. And then I'll take care of Mr. Renner, all right?
Okay.
All right, so let's get Mr. Dagger Margosian logged in. Ma'am, what are you here for?
My son John White Eagle Senior.
So that Mr. White Eagle withdrew his plea and wanted a trial on it. So his next court date is going to be January 20th at 8:15, okay? All right, thank you. All right, so I'm going to assign Mr. Dagger Margosian, Ms. Hennigan, and Mr. Tate to a breakout room. Mr. Tate, I don't know if you'll automatically go, or you'll have to click on join or have them use the mouse to join.
Okay.
All right. Oh, he automatically went. Okay. All right. So, Mr. Malaro, are you ready on Mr. Renner?
I am, Your Honor.
All right. So let me get Mr. Renner's files. Okay, so this is in the matter of the people of the state of Michigan versus James Vernon Renner. We have multiple files, 19-19341 FH, 21-20539 FH, 22-21119 FH, and 22-21120 FH. This is the date time set for sentencing. Miss Hennigan, you got to join the breakout room. Miss Hennigan? There she is. All right, Mr. Malaro represents Mr. Renner. Mr. Malaro, did you receive a copy of the pre-sentence report?
I did. I also received the probation violation report as well.
Yep. All right, and I believe, afford you guys a breakout room. Have you had an opportunity now to discuss those with Mr. Renner?
I have, Your Honor.
All right, Mr. Renner, you and Mr. Malaro went through and reviewed the pre-sentence report as well as the probation violation report.
Yes.
All right, are you satisfied? And you've had an opportunity to discuss those with Mr. Malaro?
Yes.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, I am.
All right, Mr. Malaro, I would just note though, Mr. Renner, I verified this yesterday, I called and checked. He was not approved for drug court.
Oh, it says he was.
Yeah, I know, but he wasn't.
Oh,
Judge.
Yeah.
Ms. Teskey indicated he was as well. But
I called Ms. Teskey yesterday. Is she in the office?
she isn't.
I called Ms. Teskey yesterday because I wanted to just make sure. So let me contact Ms. Teskey.
maybe I'm reading this wrong, Judge, but I thought it said he was.
No, it does say he was. That's why I was like, oh, okay. But hold on. So I just sent a message to Ms. Teskey to zoom in. I don't know. Michael, I don't know if you or Mr. Stevenson, if you have a way to reach her better than, oh, wait, she did. She just zoomed in. Okay, perfect. All right. All right, Ms. Teskey, we are right now on the matter of Mr. James Renner. And is Mr. Renner the one I called you about yesterday to verify drug court?
He is, Your Honor.
And was he admitted to drug court?
He is approved. He needs,
Who was it I called you on that wasn't approved?
Brandon Davis.
Okay. All right.
He
So
has
he
been
was
approved, but with residential first, so he probably needs a term of incarceration and released early to attend residential treatment.
all right. I'm sorry, Mr. Renner. I called on a bunch of people yesterday. So, all right. Thank you, Ms. Teskey. All right. Okay. So sorry about that, Mr. Malaro. So, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge, Your Honor.
Okay, file number, let's see, it's these guidelines on file number 22-21119. The probation department has computed the minimum sentencing guidelines to be on the attempted possession of methamphetamine to be 7 to 23 months. Do you agree with that computation of guidelines?
I do, Judge.
Okay. Does the pre-sentence, okay, so, and Mr. Renner, you're satisfied with Mr. Malaro as your attorney?
Yes.
All right. And right, he has 2 prior misdemeanors, 4 prior felonies. And there were no changes to the body of the report, Mr. Malaro?
No, Your Honor.
All right, before the court passes sentence, is there anything either on the pre-sentence report or the probation violation report that you would like to address the court?
Your Honor, Mr. Renner, people have a serious drug addiction. They have to hit rock bottom before they can rebuild their lives. I think Mr. Renner is there. He wants to do drug court. He understands that it's going to be a tough challenge for him. But he's 34 years old. He wants to be a productive member of society. And I think he understands that one, this addiction is preventing him from being so. Second, that drug court, and him and I have talked about this, is going to be a very tough challenge for him. But I think that even though a lot of times people in drug court have some setbacks, I think Mr. Renner's ready to face those, take them on, and I am hopeful that he will come out the back end of drug court a far better man and have beaten this addiction and can show not only the court, but himself what he can become when he successfully completes this. So I'd ask the court to let him enter drug court. He understands that there's going to be a period of time of inpatient rehabilitation. And so we'd ask the court to follow that and impose that for him.
All right.
Thank you.
Thank you. All right, so Mr. Renner, is there anything you'd like to say on your own behalf?
I'm just ready to get my life straightened out and show everybody that I'm capable of being better than what I am right now.
All right, Mr. Renner, do you still have a valid driver's license?
Yes,
Is it a CDL? You drove a tow truck, right?
it's got a chauffeur's license. It's not CDL.
Okay. All right, good. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record of this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. Mr. Renner, I mean, you seem to have many talents. Obviously you've worked as a mechanic and a tow truck driver, so you have a lot of capabilities to succeed. Drug court is not an easy program. And the biggest struggle I see people with in the beginning is you have to just basically turn over your life to the drug court program. So your job is not the most important thing in your life. Your relationships are not the most important things in your life. During that first phase, the whole focus is on you. And that's really hard for people. So you just kind of got to go with the flow with it and work on it every day. I've seen people that I never thought in a million years would be successful at drug court turn out to be the most successful. And people I thought that were going to succeed, not. So, there's no predetermination on how you will do. It's just how hard you're willing to work at it. And, your work record shows that you're capable of doing that. So it's sent to the court on file number, let's see. So this would be file number 21-20. Okay. We sentenced to probation for a period of 3 years on two files, 22-21119FH and 22-21120FH. And then on file number 21-20539FH, will be placed on probation for a period of 2 years because that's the misdemeanor. I'm going to order that on file number 21-20539FH. You serve 1 year in the Ludwig County Jail with credit for 82 days already served, but you can be released from jail early to enter a residential treatment facility. All right, and those facilities are like 90-day programs. And they have aftercare sometimes. It just depends on what they offer. So you won't do the year in jail. You'll be able to go to a rehab facility, okay?
Okay.
There'll be $750 in court costs, and I'll assign those all to file number 22-21119FH. So on that file, $750 in court costs, $450 in attorney fees. Now on, let me see if this is broken down somewhere. So Mr. Stevenson, on both of the felony files, there is $68 in state costs, correct?
Yes.
And then on the misdemeanor file, there's a $50 state cost, correct?
Correct.
And then on a crime victim rights fee, that's per file. So let's see, her file. So on file number on file number 21-20539FH, there's a $75 crime victim rights fee. And then on file number 22-21119FH, there is a $130 crime victim rights fee. And then on file number 22-21120FH, there is a $130 crime victim rights fee. During the term of probation, you will obey and comply with all the articles of your probation. And you'll be given a copy of those to sign and review. You're not to use any controlled substances, illegal or legal marijuana, any kind of drugs. You can't use those. If you get a prescription medication, that might be some type of opiate or Adderall or something of that nature, you have to have permission before you can use it. You understand that?
Yes.
Painkillers, can't use them without permission, things of that nature. You'll pay the cost of substance abuse counseling and testing if necessary. You must complete your residential substance abuse program. So you can't leave, you can't violate and get in trouble. If you do, it's a violation of probation. You understand?
Yes.
All right, there is a $30 per month supervision fee, 60 if we have to use a tether, and I'll assign that on file number 22-21119FH. And that's it for that file. And then on the violation of probation, let's see. It's a recommendation that you will serve 6 months in the Illinois County Jail. You may be released to an inpatient program or at the discretion of the Illinois County Drug Court, and your probation will be revoked, and I'll give you credit for 47 days. So, Mr. Stevenson, anything else?
No, I think we're good, Judge.
Mr. Renner, do you have any questions? You look like you have a question.
Yeah. How do I get into the or the residential program, I guess?
Oh, that's fine. That's a good question. So Ms. Teskey, you're going to be under her jurisdiction now. So Ms. Teskey will get in contact with you. They probably already got feelers out for the next bed available. Usually we can get people into a facility within a couple weeks. So it should be fairly quickly, but Ms. Teskey handles all of that. All right. All right, Mr. Renner, I look forward to seeing you at the drug court meetings. You probably Zoom in for a while and then be coming in person, but it's a really good program and I wish you the best of luck.
Thank you.
Thank you.
Thank
All right,
you.
you're all set, Mr. Renner. Thank you. So, I'm done
Kind
with
of
the
scared
jail.
me there for a second.
I called on a bunch of people yesterday, so I apologize. All right, Mr. Tate, grab your files. All right, so we are back on the record in the matter of the people of the state of Michigan versus Harold Glenn Tate Jr., file number 22-21132FH, in which Michael Dagger Margosian is appearing. And then on file number 22-20934FH, we have Ms. Tamaris Hennigan. This is a date and time of sentencing in this matter, Mr. Tate. You previously had waived your right to be present in person for sentencing, but once again, you're in Jackson County. So I just want to make sure, are you comfortable proceeding via Zoom today?
Yes, ma'am.
So Mr. Tate, have you had an opportunity to read and review the pre-sentence reports with your attorney?
Yes, ma'am.
All right, are you satisfied with both of your attorneys and the advice that they've given you?
Yes, ma'am.
All right, I will start first with the oldest P number. So Ms. Hennigan, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, there's nothing that that needs to be challenged in the pre-sentence report. So I will state that Mr. Dagger Margosian did discuss that with his, does not state whether these sentences will run concurrent. And so that is a question that we will each have for the court.
Okay, Mr. Dagger Margosian, with regard to the accuracy or relevancy of any information in the pre-sentence report, do you have any observations?
Your Honor, notwithstanding my P number discrimination.
Oh, your
that I
P number
just-
is older than Ms.
That I
Hennigan?
just suffered. If not, I have to concede that.
Oh.
I don't have any challenges to any of the information, Your Honor. Thank you.
Okay, all right. Now, Mr. Jones did state on the record that you had spoke with him and, or was that you, Ms. Hennigan? You had spoke with Mr. Jones and some changes were made to the body of the initial 3 pages. Is that correct? Is that why there's an update?
Judge, the update, so Ms. Hennigan came to my office. The changes were very minor in regards to a spelling of her name. And that was why I sent the other pages back to the court again on her particular PSI. It's because she came to me and wanted the change. So the update is Mr. Dagger Margosian's PSI. The changes were just at the request of Ms. Hennigan of a spelling correction.
I would just add, also it was a change of the length of years that Mr. Tate had been using alcohol. The date that he began his use was 20 years before the date of his birth. So we asked for that to be changed too, because that was an impossibility.
Okay, Mr. Jones.
Judge, also, I just want to put on the record that because we have those drug subs, that those guidelines did go to 0 to 34 from 0 to 17 on both PSIs, because both files were second offense drug subs. And then also jail credit is 100 days even on both PSIs. Because we adjourned this.
So, okay, so on the sentencing guidelines for the controlled substance possession of cocaine less than 25 grams, it's 0 to 30 and not 0 to 17.
It would be 0 to 34 because it's a drug sub second offense, and it was 0 to 17, so that just doubles the back half of it.
Okay.
For some reason, the computer doesn't do that for us.
That's fine. And that would be on both files.
Correct.
But the guideline sheet would remain the same. It would only say 0 to 17.
Correct. That's correct.
Okay. So, Mr. Dagamar goes in, or I'm sorry, Ms. Hennigan, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? You're muted. Still muted. You're muted.
Yes.
All right. Does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No.
All right, Mr. Dagger Margosian?
None to my knowledge at this time.
Mr. Dagger Margosian, on your file, let's go to Ms. Hennigan. So Ms. Hennigan, on file number 22-20934FH, the probation department calculated the minimum sentencing guidelines to be 0 to 17, but with the drug sub, it becomes 0 to 34. Do you agree with that computational guidelines on that count?
Yes, Your Honor.
All right, and then on the count for felon weapons, firearms possession by a felon, the probation department calculated the minimum sentencing guideline to be 7 to 23 months. Do you agree with that computational guidelines?
Yes.
All right, Mr. Dagger Margosian, on your file, the probation department calculated the minimum sentencing guidelines to be 0 to 17 months. But with a drug supplement, the guidelines are now 0 to 34 months. Do you agree with that computation?
Can I just have a moment just to look into that issue? I agree that the drug sub certainly doubles the back end of things to make it an 8-year. I just want to have 1 second just to see something.
Hold on, Mr. Tate.
Your Honor, I guess what I'll say is, at this time, I don't have any challenges to the guidelines being scored 0 to 34. Yes, I just want to put a quick caveat in that if I'm wrong, if we're wrong, that the minimum is not doubled by a drug sentencing enhancement, I just want that to be preserved. But at this time, I don't have any challenges.
Well, it's like this is sentencing, so
At this time, I don't have any
if you
challenges.
need 5 minutes to look into whether it's appropriate, I'm more than happy to give you that 5 minutes.
For the record, I've read the statute, the enhancement statute. The language indicates that the possible incarceration would double, so I would think that that would include the minimum. So that's what I have.
But it's not the minimum of the guidelines, the challenge.
Correct.
Okay. Okay, before the court passes sentence, Ms. Hennigan, on your file, is there anything you'd like to say on behalf of Mr. Tate?
No, thank you, Your Honor. He's been before
Alright.
you before, and we know him well, and we know his character well and challenges. So I would just say that he's continues to work on his addiction issues and does well when he's in a structured environment. And I believe that he will do well moving forward when he's released.
Alright. And Mr. Tate, why are you in Jackson County Jail?
I was the victim down there, but the sheriff shooting me.
Oh, so they're just housing you?
Yeah.
Okay, so they're housing you there. Got it. All right, Mr. Dagger Margosian, is there anything you'd like to say on his behalf?
I think the recommendation is appropriate. The 100 days of credit we think is accurate. Both Ms. Hennigan and I believe that these sentences certainly should run concurrent to each other. I think that was even part of the sentencing agreement, but I'll just jointly request what Ms. Hennigan is stating, that the recommendation is appropriate. I would ask the court to follow it. I think Mr. Tate is going to benefit from the sentence, benefit from probation. So that's my request to the court.
Ms. Adams, could you let the jail know? I'll take Mr. Spresser if there's a pickup.
Okay.
All right, so Mr. Tate, is there anything you'd like to say on your own behalf?
No, Your Honor, I just appreciate the decision of the court.
And so the sentencing, all right, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, sentencing guideline or statutory penalty, cost of confinement, sentencing guidelines, report and recommendation of the probation department, as well as what has been said upon the record at this hearing. Criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law and the protection of society. All right, on file number 22. Dash 20934FH. It's a sentence of the court that you'll be placed on probation for a period of 3 years. You'll be ordered to pay $750 of court costs, $130 crime victim rights fee, $136 in state costs, a $60 DNA fee, and $30 per month supervision fee. 60 if we're required to have a monitor. Isn't so the COBS agreement to 1 year jail was on Mr. Dagger Margosian's file?
I think they were on both.
On both?
I believe so.
Okay.
That's correct.
Yes, Your Honor, they were on both.
Okay. So on Mr. Dagger Margosian's file, never mind. on Ms. Hennigan's file, I'm gonna give you credit for 59 days already served. You're ordered to comply with all the articles of your probation. Mr. Jones will review them with you. On your other file, you're gonna do the year in jail. But, Mr. Tate, when you're done with your jail term, you're gonna need to report to Mr. Jones like that day or 8 o'clock the next morning on a weekday. Do you understand that?
That's fine.
Okay.
Judge, credit on that 3934 is 100 days as well.
I'm sorry, it only said 59. I'm sorry.
Yep, I'm sorry.
So I'll give, so on the 934 file, I'll give you credit for 100 days and on the, okay. For time served. All right, so then on Mr. Dagger Margosian's file 22-21132FH. It's a sentence in the court that you'll be placed on probation for a period of 3 years. I've already ordered court costs on the other file, Mr. Jones. So I wouldn't order them on this one, right?
You do what you want, Judge. They're two separate dockets on two separate instances. I'm just required to put it in my report.
All right, so if they're paid, I'm gonna order $750, no, I'm not. I'm not going to order $750 in court costs. I am going to order a $130 crime victim rights fee, $68 in state costs. No, I'm not going to order the DNA fee because it was already ordered on the other file. Does he pay a supervision fee on each file or just one?
No,
time?
Judge, just that's fine. We'll combine those.
All right, I'm not gonna order the supervision fee on this file. And I'm going to order that you serve 1 year in the Lenawee County Jail with credit for 100 days. You're to have no contact with the individual with the initials SS, directly or indirectly. You're ordered to obey and comply with all the terms of your probation. There's a $450 court-appointed attorney fee on this file. I said it on the other file, but that was incorrect. You must obey and comply with all the articles of your probation. So Mr. Tate, Mr. Dagger Margosian had the agreement that you would serve no more than 12 months. I ordered it on that file. So as I said, once you complete that jail term, when you got to come right back and report to Mr. Jones. So if you get out at 6 in the morning, contact Mr. Jones at the courthouse and check in, all right?
Yes, ma'am.
All right, Mr. Jones, how will you be going over the probation terms with them?
He will, when he reports to me, I'll go over them with him. If as long as
Okay.
he's incarcerated. Judge, one question. Did you order 1 year jail on 934 file as well? The first file?
No,
You did not?
I just ordered it on the 3-2 file, Mr. Dagger Margosian.
Okay, because that was an agreement on that file as well. I just want to make it aware to the court. And I'm not sure if if the prosecutor had a reason for that, but I just want to make it aware to the court that I do show it that it's agreed upon on that as well.
Well, Cobb's is between me and Mr. Dagger Margosian and Ms. Hennigan. I can order the year or Ms. Hennigan. I'm not gonna order the year on that one. Okay. All right, so somehow, Mr. Tate, we're gonna get over to you. 3 copies for each file of your notice of right to appellate review. And then we'll need you to sign 1 copy of each of those.
Okay.
And then they'll send them back to us. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the court within 42 days. I realize you're in Jackson County Jail and they've worked with us really well, so I assume they'll get the paperwork to you. But if you think you want to appeal your sentence now, because you're in Jackson, I'm just concerned about the paperwork. You can let the court now and I can process that. Do you need time to think about it, or maybe you won't, or do you want me to do that today or no?
I appreciate your decision and I'm fine with it. I'm cool.
Okay. All right. Thank you, Mr. Tate. I wish you.
The only thing I'll add is, I think you had said that it would be 1 year Lenawee County Jail. Obviously, he's in Jackson. I just don't want the paperwork to get mixed up.
All right, so Mr. Dagmar goes and makes a good point, but we have an agreement with Jackson County, that's where he'll be.
Sure, sure. And so if we can just, a year in either Lenawee or Jackson, I mean, just to construct it so that. it
So
doesn't-
I don't have jurisdiction. It'll be taken care of. He's not coming back to Lenawee. So Mr. Tate, Mr. Dagmar goes and just wants to make sure the paperwork makes it clear that the 12 months that you're serving will be done in Jackson. So Ms. Adams, if we can add some language that the 12 months to be served at, I don't know, somehow we need to add something that it'll remain in Jackson, but they're not bringing them back.
I mean, honestly, just a year in county jail or just something.
It's an
generic.
agreement our county jail has with Jackson County Jail. You see what I'm saying?
I got you.
I don't have jurisdiction to send them to Jackson County Jail. I mean, I think most people like Jackson County Jail better because it has a yard, right, Mr. Tate?
Yes.
So, all right, thank you, Mr. Tate. Wish you the best of luck.
Thank you.
Thank you.
Thank you.
Okay, thank you. Mr. Daggermos, you want to approach?
I'll be there 1 to 2 for the county sheet when you can. Apparently they don't see you.
Alright, so I, and then if Jackson, I just want, like, in case like DOC's like, oh, it's a Jackson, and it was, you know, yeah. Alright, thanks.
And he's been there before a million times anyway.
Thanks.
All right, who do I have joining me from the jail?
This is Mr. Spresser.
Good morning, Mr. Stresser. So, Miss Adams.
Judge, I believe he's on the phone. Yes, Judge.
I don't have paperwork on Mr. Stresser.
Oh, I gotta bring that in. Sorry, didn't know you were on that.
Mr. Malaro, do you have Miss Bell?
I'm not aware that she's here. I'll check out front, but doesn't look promising, Judge.
No. All right, so this is in the matter of Lisa Leora Coopshaw versus Joseph Paul Spresser, file number 2007-32101DS. Mr. Spresser, we are here on an order to show cause and a bench warrant for failure to appear. Looks like you were ordered to appear in front of this court on December 12th of 2022 on a show cause for failure to pay child support. And you failed to appear on December 12th. And then also you're ordered to pay $202 a month in child support. You have an arrearage in excess of $2,589. And the last payment we received was on December 7 of 2022 for $78.48. Do you understand that, Mr. Spresser?
Yes, ma'am.
Now, Mr. Spresser, you have prior contempt. So if you plead guilty or are found guilty of the contempt of court on either of those, you can be facing up to 93 days in jail. Do you understand that?
Yes, ma'am.
Actually, it's only 90 days because it's contempt. So, Mr. Spresser, you do have the right to have an attorney represent you here today and any subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
No, ma'am.
All right, Miss Adams, the friend of the court worker, Sue. I need her to log in too.
Yep, I'm gonna call her right now.
So you do not want a court appointed attorney?
No, ma'am.
All right, will you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you put your hand down. Can you state your full name for the record?
Joseph Paul Spresser.
All right, so Mr. Spresser, do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes, ma'am.
Do you understand that it's a crime to fail to appear here in court when you're ordered to appear?
Yes, Your Honor.
You understand the maximum penalty if you plead or are found guilty could be up to 90 days in jail, as already said. Is that correct?
Yes, ma'am.
Now, you're entitled to have a trial and you cannot be convicted unless the evidence at your trial proves that you are guilty beyond a reasonable doubt. Do you understand that?
I do, Your Honor.
Now, I've offered you a court-appointed attorney and you've declined that, so you do not want court-appointed counsel. Is that correct?
That is correct.
All right, now, sir, you are entitled to have a hearing on this and have all the witnesses against you appear at your trial, and you would have the right to question those witnesses while they're under oath. Do you understand that?
I do.
You're also entitled to have me order any witnesses you might have to appear at your trial on your behalf. Do you understand that?
Yes, Your Honor.
You do not have to say anything at your trial, and if you do not testify or say anything, nothing will be held against you, and in fact, no one will even mention your silence. Do you understand that?
Yes, ma'am.
On the other hand, do you understand that you are entitled to testify at your trial if you want to testify? Do you understand that?
Yes, ma'am.
How do you plead to the charge that you have failed to pay child support to the very best of your ability up to the amount ordered? Guilty or not guilty?
Guilty.
And how do you plead to the charge that you failed to appear in court for a show cause on December 12 of 2022? Guilty or not guilty?
Not guilty, Your Honor.
Okay. Mr. Espresser, do you still live in Blissfield?
Yes, ma'am.
Do you live on Cherry
Well,
Street still?
That's still my mailing address, yes.
So your mailing address is 333 Cherry Street in Blissfield, Michigan. Is that correct?
Correct.
Okay, I do show that our notice of hearing was mailed to that address. Now, you said that's your mailing address. Does that mean you don't actually live there?
Correct.
Okay, and did you appear on December 12th of 2022?
I did not, Your Honor. I did not actually receive notice of that. And I actually had a show cause on the 7th of December for a different case. I was in the hospital for during that time, and my caseworker called me back prior to the 12th, never informed me about this show cause on the 12th.
Okay, but are you saying you never received a notice in the mail for December 12th?
That is correct.
Okay, all right, and where do you live?
I'm currently homeless.
All right, now, Mr. Stresser, you have an order to pay $202 a month in child support, is that correct?
That is correct.
And are you employed right now?
I'm sorry?
Are you employed?
No, ma'am.
Okay, the last payment we received was $78.48 on December 7th. Were you employed at that time?
No, ma'am.
Okay, all right. When's the last time you were employed?
I don't have paperwork in front of me, but it was August, September, around September.
Okay, and would you agree you have an arrearage in excess of $2,500?
Yes, ma'am.
Okay. And when you say you're homeless, are you couch surfing or are you literally without a place to stay?
Well, I was in my my truck, but it's an impound now. All my personal belongings are in my truck, everything, my tools. So.
Okay, I accept the plea on the failure to pay. It has been given understandably, voluntarily, and accurately and knowingly and full knowledge of your rights. So you haven't worked since like August, September?
I mean, I do side work here and there, but now that my vehicle's impounded with all my tools in it, it's gonna be kind of hard to do anything really.
And you have family or anybody in the area?
Friends.
All right, before the court passes sentence, is there anything you'd like to say on your own behalf? Other than that?
Just that I'd like to be out by Monday. My son's birthday's the 16th. He'll be 16.
Is that the child on this case?
Yes, ma'am. He also has a basketball game today.
He has what?
A basketball game this evening.
Mr. Spresser, what's going on in your life that you're struggling with employment?
Just housing, really. I was working out in Out of the Lake and staying with a friend out in North Adams. The vehicle I have, the fuel gauge doesn't work. My employer was gonna help me out with getting a fuel pump to fix the issue, and 2 weeks went by. They didn't do anything to help me like they said. I was late again. They fired me, so it's been a struggle.
All right. All right, so Mr. Spresser, do you have any other court cases going on?
Just these two now.
What's the other one? The other child support case?
Yeah, yes, ma'am.
Were you seen today on that? I only have one.
No, ma'am. I think it's in front of Sala, but it was, like I said, I was in the hospital. I thought I had a blood clot in my leg. I was having some problems with my leg.
No, have you already gone to see Judge Sala?
No, not
Judge.
today.
Yes, Ms. Pelham.
That case was with Judge Sala, but we transferred it up to you. So I went ahead and dismissed that bench warrant and everything. And we're going to start over with a new show cause, but we wanted to handle this one first.
All right, Mr. Spresser, you don't owe the most amount of child support I've ever seen in front of people. Well, for people that come in front of me, but so I'm going to give you one chance, Mr. Spresser, to one, find employment, two, get some resources. You live in Lenawee, right?
Yes, ma'am.
You know, there are resources out there that will help you fix your vehicle and find housing. There's like, they just opened up a men's housing pretty soon in Tecumseh to help people get back on their feet. So I know, do you have anything to pay on this today?
No, ma'am.
All right. So
That's another thing, Judge. If I could just say, like I said, I've been doing side jobs. Cutting, it's winter time, so cutting wood and chopping wood. I've had 3 or 4 people that haven't paid me for helping them. I mean, there's a couple $100 that people owe me, and that's another thing that set me back. And I know it's not your fault or whatever, but it's just really frustrating.
Right. I get it. All right, so Mr. Spresser, I'm gonna give you one chance. I'm gonna give you a pair bond today. I'm gonna set sentencing for February 6th of 2023, which means you gotta be here in my courtroom on February 6th of 23. Your paperwork is going to be given to you when you leave the jail, and that'll be at 8 a.m. All right. We have a list of, yes.
Can we adjourn that out further just in case, make sure we're back in the office list like to February 27th? Would that be okay?
Sure.
Okay, thanks.
All right, we'll set that to February 27th then. So, Mr. Spresser, we have a list of over 1,500 employers in Lenawee County. I don't care if you got to get a job washing dishes, bussing tables, whatever, just anything that'll help you fix your truck, get you back on your feet again. There's a lot of resources out there. I don't know if there's substance abuse, mental health, or alcohol behind this, but, reach out and get some help. We have resources in our county. I mean, for a small county, we have a lot of resources available. So February 27th of 23, when you come back, I want to see that you have a job and you've made some payments, all right?
Okay.
Okay, so I'll see you back on February 27th of 23 in person. Thank you.
Okay, thank you.
Are you here on the 9:30?
Yes. And
Are we all set, Your Honor, at the jail?
Yeah, we're all set. Thank you. Mr. Malaro, in the matter of people of the state of Michigan versus Evelyn Marie Bell, file number 22-21148H, Mr. Malaro, have you been able to locate Ms. Bell?
Judge, I have not been able to locate Miss Bell.
Let's see who this is. Got an iPhone. All right, I have someone who's logged in on an iPhone. Can I ask your name, please?
Michael Lewis.
All right, Mr. Lewis, I'm going to change your screen name and then pop you in the waiting room, and then we'll call you in just a moment, all right?
Okay.
Right, well, Mr. Malaro, Ms. Bell has failed to appear. She also failed to contact the probation department. We're here on a use of methamphetamine charge, so she had a misdemeanor. Was a pretty good deal, so I'm gonna issue a bench warrant for her arrest. And I will set bond in the amount of 150,000 cash.
Woo, all right, Judge. All right, Judge, thank you very much.
Thank you, Mr. Malaro, and you have a great day.